Hello, and welcome to the lecture series for Ethics in the Legal Environment at the University of Mississippi. This is the second lecture in a unit on firm structure and management. In the last lecture, we discussed the ethical responsibility of supervising attorneys like partners or managers for subordinate attorneys. In this lecture, I'm turning to the ethical responsibilities in the relationship between supervising attorneys and paraprofessionals. Paraprofessionals are the people with the appropriate education, knowledge, and training to perform specialized work under the supervision of another professional who has ultimate responsibility for the collaborative work. Paralegals are the paraprofessionals of the legal environment. As we have discussed many times, the ultimate responsibility for work that goes out the door of the law office falls at the feet of the supervising attorney, even if the work was performed by a paralegal. You should also remember that it is necessary for clients to understand and be aware of the roles played by paraprofessionals in rendering legal services. It is also the role of the lawyer to properly limit the roles of paraprofessionals. Mississippi Rule of Professional Conduct 5.3 provides that attorneys have an ethical obligation to prevent the unauthorized practice of law by unlicensed people. However, paralegals should also be diligent to recognize when an attorney is not directly supervising them or when the supervision or review of work is illusory. When such supervision is illusory, the paralegal is engaged in the unauthorized practice of law. In the relationship between an attorney and a paralegal, the attorney never has the excuse that some mistake by the support staff was the support staff's fault. Even where, quote, someone else had the requisite skill and knowledge to complete the task, an attorney who is licensed takes on the ethical responsibility for the work of the non-licensed legal professional. The obligation of the supervising attorney is not relieved because of his or her confidence in the abilities of the non-lawyer assistant. Everything that goes out the door must be held to the quality of work of the lawyer. The possibility of the unauthorized practice of law is raised when disbarred or suspended lawyers are in the law office. It isn't unique for attorneys who have faced bar discipline to continue employment with a firm but without practicing law, particularly if the disciplined lawyer is a partner or shareholder in the firm. They may continue to work and even receive compensation from the firm. However, this brings up serious questions because if they engage in work independently without the supervision of a licensed attorney, they are engaging in the unauthorized practice of law. The Mississippi Supreme Court considered this type of situation in a discipline case styled In Re Reinstatement of Parsons, in which a lawyer sought reinstatement to the bar but was discovered to have engaged in law practice while he was suspended. The attorney who was the subject of this case, Eddie Parsons, was convicted in 1996 of drug and solicitation felonies. He was incarcerated for nearly 6 years and was disbarred. Subsequently, he applied for reinstatement. In Mississippi, the fundamental question in reinstatement is whether the attorney has rehabilitated himself in conduct since the sanction was imposed. So the Mississippi Supreme Court in 2002 referred the reinstatement petition of Parsons to a special master to make some factual findings. Before the hearing with the special master, counsel for the Mississippi Bar was notified that Eddie Parsons was working in the same office occupied by his father and brother, who were licensed attorneys. The Mississippi Bar alleged that Parsons was practicing law without a license while disbarred. A secretary in the office testified that Eddie would sign his brother's name to pleadings and discovery, and that he would request law firm files so that he could discuss cases with his father and brother's clients. Eddie admitted that he met with clients, but that he never offered legal advice. When his reinstatement petition came back to the Supreme Court, Justice Waller wrote for the majority, continuing to do what is at the very least the appearance of law practice in his old office with current and former clients makes a mockery of the disbarment. Eddie Parsons' actions reflected a disregard of the consequences that come with disbarment. Now, ultimately, the Supreme Court denied Parsons' petition. While a lawyer is suspended, he must be treated like other paraprofessional staff and must be supervised. As with any paralegal, the degree of review will be dependent upon the experience and record of the person in question. The 30-year paralegal, with a lot of experience and zero ethical issues in her time, may need little supervision in day-to-day tasks which she has performed thousands of times. Meanwhile, a brand new paralegal who has made some understandable mistakes of a newcomer might need special supervision and review. Fundamentally, though, paralegals are professionals. Many are considered to be indispensable to the law practice. Stay in the legal business long enough, and you will meet a lawyer who retired because his paralegal retired, and he did not look forward to the prospect of training someone new. One final note about firm structure and non-lawyers has to do with fees and business associations. Licensed attorneys are limited in their associations with non-lawyers. Principally, lawyers are not permitted to share legal fees with non-lawyers. Legal fees earned are a result of legal work that only attorneys can render. This means that paralegals are not permitted to take percentages of a jury award, for example. Paralegals cannot be paid incentives based on the results of particular cases. Lawyers in partnership with each other often have a fee-sharing arrangement. The fees earned by all the partners are pooled together, and after paying the expenses of the office and the salaries of the non-lawyers and associates, the profits are distributed on a percentage basis to the partners. It is not ethical for non-attorneys to participate in this fee sharing. Our continuing discussion of ethics in the law office turns next to a subject that has amused many and disgusted others: attorney advertising. Until next time.